that even for today, the issue of cost should not be an issue, because we have served notice of our intention to withdraw this matter already on the 4th of June. And it came as no surprise that we are here today. We cannot be faulted for bringing it to the court to say we have not received consent, we seek the consent of the court to endorse what we have already put forward, party and party. But if my learned colleague, the first and third defendant, is of the view that they are entitled to punitive scale, I'm sure they have a right to be heard, and I will have the right to respond.
Yes. But with regards to the other years, as you say that there's been bundles and bundles, some people who have just fallen out and then coming in, obviously that one has to be prepared.
Certainly.
That is why I was just focused on the issue of today regarding those costs.
Yes.
All right, I understand. Mr. Mangwalele?
On the issue of costs, in as much as indeed one would have liked to prepare in the light of the draft order that was furnished and the attempts with regard to the costs. But my lady, firstly, the notice that was uploaded, I think it's 074/3. In terms of that notice, my lady, and this is the notice by the first and third defendants. It says, take notice that the first and third defendants, in case number 14038/19, and the 33rd respondent in case number 11935/16, intend to make application to this honorable court on 24 July 2025 for an order in the following terms. One, it is declared that the notice of withdrawal, in quotes the notice of Leonard Mudisa, the plaintiff case number 14038/2019, and any counterclaim in case number 11935/16, as served on 4 July, constitute an irregular stay. Let's start there. The issue here is an irregular notice was indeed served. And same as cured, it's just the issue of computation of days as to within how many days should
That have been done, yes.
But it can be done even before the exact date to avoid the issue of costs. And that was cured timelessly. And my lady, the reason why we are here is because we are seeking leave from the court, because we never received any response. And had perhaps the response came and said, no, we have 10 days, we will argue the issue of that issue of consent or not, we will do it on the 10th day. That will be something. Rather than to be, I'll for lack of a better way, I'll say this will become litigation by ambush. And we need to be collegial as officers of the court. And we can respond within. Does not necessarily mean that we have to wait until the last day. So, my lady, the second paragraph says the notice is set aside. Now, which notice? Fine. Third paragraph says Leonard Mulise is to pay cost of this application of the first and third defendant and 33rd respondent. It says nothing about the second defendant or the applicants in the application. are said to be in default. But what is being sought before court in terms of the notice, or what we are informed, that it will be the relief that will be sought before court does not correspond with what is contained in the court. And as a result, my lady, one submits that this would be litigation error.
No, but this application, this notice of motion relates to the plaintiff.
No, my lady. No, the application is not related to the plaintiff. And my lady, if your ladyship looks at the application, the parties cited there, and that's where I'm coming to. In terms of the 33rd respondent seeking costs, my lady, this matter is history. And there are orders that were made, which still stand. And one of the orders made, my lady, was that the parties, as the reflections, should meet, convene a meeting, and agree to take a resolution. And same was done. And subsequent to my lady, there was a formation of the executive committee of the church in terms of the constitution, as well as the council. And they are the ones that took resolution on whether the 33rd respondent, which is the church, should oppose the application or not. And that's the basis upon which the 33rd respondent was joined. And normally, as matters stand, we don't know the status of that executive committee, as well as the council that took a resolution. Now the issue is, where does the 33rd respondent get mandate when there is a court order? And court orders, my lady, I submit, they stand until rescinded or set aside. And I'll just refer your ladyship to the matter of Standard Bank against Luka Dr. where your sister, Madam Justice Jansa van Nieuwenhuizen, J, said referred to Makala's decision of the SCA. And that is on page 5, where it is said that in the Makala decision, the Supreme Court of Appeal reaffirmed that all orders of court, whether correctly or incorrectly granted, have to be obeyed until they are properly set aside. Reference was made to the case of Lewis and Marx versus Miller, it's a 1904 decision of 2S291, in which it was held that where an order was null and void, a court may, upon proof of such invalidity, disregard the judgment without the necessity of a formal order setting it aside. But my lord, there is no allegation at my lady, there is no allegation or any evidence to the effect that all court orders are annulled. And my lady, they still stand until set aside. Firstly, my lady, the first defendant is not a party, is not cited as a party in the application. And the third defendant is cited on the basis of a joiner and as a result of a court order, stemming from the resolution taken by members of the council and members of the executive committee, who are no longer current as we speak, are not before court, are not confirming anything insofar as the instructions are concerned. And therefore, my lady, my submission is that there's no mandate. legal mandate to seek such a relief. The mandate is questionable to seek such a relief insofar as the application is concerned. Coming to the action, once the action is withdrawn, we withdraw our counterclaim. And we also withdraw the application, which of course the said application, we are informed that there was a consolidation, and that is in terms of the submissions or the correspondence received from the first and third defendants' attorneys, that there was a consolidation. We normally, in terms of Rule 11 of the Uniform Rules of Court, consolidation can only be granted by an order of court. And my lady, I have not seen any court order consolidating the application and the action. The rule is clear that consolidation should be made upon the application of any party.
Is it not too late for you to be saying that? Because all this time, these cases were consolidated and they were referred to as such. And there has never been any problems.
My lady, we are sick, we are correcting the wrongs. And if I submit it is not late. Your leadership would remember that in the previous occasion, I indicated that I've never attended any case management meeting, and I've never seen any minutes of the case management. I came on board shortly before the trial commenced, and my lady, we were expected to file documents, and indeed those related to the application.
Let us not go there. Is it you're talking about what I understand? You correct me if I'm wrong. You're saying that the fact that the 33rd respondent was roped in because of the agreement that was put in place, it has no, legal standing for it to be asking costs against your client.
The third respondent, as is now.
Yes.
In the action.
In the action, yes.
There's no local standing
Yes.
to be asking costs against my client insofar as the application is concerned.
Yes.
And the 33rd respondent, there's no mandate, or the mandate is questionable for the case, since it comprised of different people. As I was saying, the rule of practice, and I'm referring to the Uniform Rule 11,
Yes.
upon the application of any party. The rule of practice that consolidation of action would not be granted at the instance of a plaintiff who had sued the defendant in two different actions no longer applies. The application and order for consolidation may be made at any time, in some cases decided prior to the introduction of this rule in 1965. The distinctions appears to be drawn between the consolidation of actions separately instituted at the pleading stage and a consolidation of actions separately pleaded merely for the purposes of hearing. In the rule, no such distinction is drawn, but the stage at which the application for consolidation is made is obviously relevant to the evaluation of convenience and possible convenience. I wanted to get to.
Besides the issue of consolidation, is there any other thing in relation to, because remember when we started talking about the issue of costs, and I understand and appreciate where you're coming from because it makes perfect sense. Besides that, is there any other thing with regards to the issue of costs?
With regards to the issue of cost management, why would submit that?
Yes, please approach.
Thank you, my lady, for your
Yes.
comments. My lady, what my things are questioning is that the application itself, when it started in 2016, it was in the form of seeking a relief of an interdict. And it was not about succession. It was about interdicting those who were preventing or intending to prevent the ordinations. And my lady, one aspect was referred to oral evidence. We've been moving and moving and moving. Each time we come to court, there's something new.
But why are you bringing that up now, or are you getting instructions to bring that up now? Why are you getting instructions to bring that up now, and why are you making submissions in relation to that, particularly now? Because you're talking about something else. Now you want to take us to what was supposed to have been, if the matter would have proceeded.
Yes, my lady. My learned friend have stated that this matter is not 7 years old. And my lady, one needs to respond. And it is only now in court that my learned friend said to your ladyship, this matter is 7 years old.
Yes, but my apologies. If I understood him correctly, he was talking about the costs. That had got nothing to do with what happened or what could have happened if the matter would have proceeded.
That was my understanding, Mike.
Yes, but now you're going deeper, and I'm wondering what relevance is there in terms of what you are saying. And that is why every time when you speak, and my apologies again, to interrupt you, I'm trying to push you to what we are supposed to be discussing and not other issues.
As your leadership pleases me. And it is my submission that we have tendered costs on 13 participants.
Yes.
And that was untimely. And my lady, if we were to...
And when that has been done timelessly, there is no reason why punitive costs should go that against the client.
As your leadership pleases. And there's no reason why costs should be awarded against the applicants in the application. As your leadership pleases.
Thank you. Mr. Hassan?
I must say, my lady, and I don't say this lightly, I'm flabbergasted by what I'm hearing. They have tendered costs. The only issue is the scale of costs. The issue of consolidation is not a matter which can be raised now. And I might add, my lady, that when the matters were consolidated before the acting deputy judge president conference, there was a minute, and the minute records that the parties agreed that the two issue matters will be consolidated. Mr. Mangalele was there in that meeting. In addition, my lady, when they serve a notice of withdrawal, the notice of withdrawal has both case numbers. Everybody has proceeded in this matter on the basis that it is both cases, and in the notice of withdrawal they refer to both cases. I don't think I need to address my lady further on this. It's coming from left field. Now, my lady, insofar as the applications are concerned, first let me deal with Mr. Salala first. He says he's not ready to argue the question of costs. My lady knows how much time has been spent in this matter over the years since my lady presided over the matter from February. What did they expect was going to happen today? They were faced with an application to set aside their notice of withdrawal because they had not sought consent and they had not obtained leave of the court. If we did not give our consent, and I don't know why we were not giving our consent, and if they did not get leave of the court, they should call their first witness today. That's what we're here for. We've prepared. Over weeks, my lady, we've prepared. So they should be ready to call their first witness, and yet they tell my lady they're not ready to argue attorney-client costs. Secondly, my lady, we under courtesy this morning, we gave them a draft order in which we said, we will allow you to withdraw, provided you pay attorney-client costs. The issue of dismissal was raised, we've resolved that. That's what we're dealing with now. They've tendered costs. The only question is the scale. Nothing else serves before my lady right now. So the argument of Mr. Magulele, insofar as it goes outside of the scope of the scale, is irrelevant. We had prepared, my lady, two bundles of the applications, the Rule 30 applications, and the application to set aside their withdrawal as an irregular step, which I can hand to my lady. They paginated, but unless we're going to be dealing with that.
It's on case line.
It's on case lines, and the paginated case line numbers are here, my lady. And both applications were served on both parties, and when they tendered costs, they've tendered costs in both matters. It's only the question of the scale. Now, in terms of trying to play the victim, they blame us for not telling them that we wanted attorney-client costs and then we'd let them withdraw. They served notices, as I've said, without giving us any advance warning. We served a Rule 30 notice because it's irregular. They had not obtained consent, they had not obtained the leave of the court. When they did not respond to that, we brought an application in terms of Rule 30 to set aside their withdrawals as irregular steps. If we succeed in that, let us call their first witness. We're ready to proceed with the trials. And to raise our
And
issues,
that relates to Mr. Leonard Modise,
Yes.
because Mr. Tsepiso Modise complied.
well, it relates to both parties. Either they're ready to proceed or they're not. We are ready to proceed. But they've chosen at the 11th hour to withdraw and only tender party and party costs. And the lady, they should be ready not only to start the case, but they should be ready to argue attorney and client costs. That's not something on which they lead. We need to reconvene, postpone the matter, stand it down for them to prepare. And the lady, a lot of the facts, traces are not they all speak for themselves about why they should pay their attorney and client costs.
Mr. Salala, my apologies. Mr. Salala talks about this matter having started from 2016, and there has been, applications. No. I was talking to you. My apologies. Mr. Salala is talking about the matters having started from 2016, and along the way, so many things have happened. And if I understand him correctly, there are costs outstanding. I'm just paraphrasing. Maybe there are costs outstanding, and for him to address the court in relation to that, so he would want to break them out into pieces and then discuss them and argue them.
If there are cost orders in their favour at any time, those cost orders remain. They stand place. It's only costs where there have not been cost orders.
Yes.
And the lady can excise that and say, well, where there are orders, those orders stay. But where there are no orders of costs, then that should be argued now. And they've tendered costs. It's no different if they've tendered costs. We assume they've tendered costs outside of the court orders, but if they have got cost orders outside of that. The only issue is the scale. That's all.
And this relates to today. It has got nothing to do. I'll give you an example. We've had 3 applications before, starting from February, where orders were 2 full judgments were given, and 1 there were reasons, and the costs were sorted out in those. And today it's something else which has got to do with the withdrawal and the issue of costs. But that has got nothing to do with what happened before.
No, it's got nothing to do with
And those costs, whether they were costs or not, it's irrelevant. if I understand you correctly.
Cost orders will stand. Cost orders
If,
relating
let me rephrase. Where there were costs that were made before in other applications, obviously those has to stand. Where there were no costs, the position will still remain the same. Or then they have to be argued if I understand you correctly. But this has got nothing to do with what happened previously. We are here talking about today's withdrawal and today's costs.
No, my lady. We are
Unless if I
seeking-
don't understand you.
withdrawn. We are seeking costs from inception until now and the 20 months.
All right.
That's what we are seeking. We say they should not have run these cases as plaintiffs and applicants for all these years and at the 11th hour without any reason. The lady hasn't been given reasons, we haven't been given reasons, to simply withdraw and say, just be satisfied with your party and party costs. We say that this conduct alone, deserves costs on the attorney-client scale of the entire matter.
Of the entire matter.
Yes. That's what we want. That's what we want.
And you're saying that you are ready to
We are
argue.
ready to argue.
Is there any reason why Mr. Mr. Selala should not be given an opportunity? If I understand you correctly, you're saying that there is no reason because he knew, and more particularly because he's the one who is withdrawing. So if he knows that he is going out, he should have prepared himself to argue the issue of costs.
That is our submission, lady. Because what I understand our learned friends to be saying is that we had some kind of onus to respond to them when they haven't sought out consent, to say to them, if you're prepared to pay attorney-client costs, then we will give consent. We were entitled to time to consider that as well. There was no onus on us. They should indeed have written to say, we see you haven't given consent. Could you please give me a reason why you haven't given consent? They never did that. Up until now. Now when we considered the matter, we come to court and we say to them, in order to bring this matter to a close, after all these years, we'll do so if you're prepared to pay attorney-client costs. They say, no, we're not prepared to do that, but we will, and we want time. The lady, had we gone back to them and said to them, we will allow you to withdraw if you pay attorney-client costs.
But how? How? Let me interrupt you. When you say that, let's talk about Mr. Selala's client. How would we have done that when he did not even ask for consent in the first place?
He hadn't asked for consent.
Exactly. So then how would you have said to him, I will give you costs, or I will do this, or I'll give you consent once you agree to this? Because he hasn't done anything. And hence the application in terms of Rule 30.
But it gets worse, my lady, because had he asked us, and we said we wanted attorney-client costs, he wouldn't have agreed, otherwise he would agree today. So we would have been in the same position. But lady, it's a matter which has gone on for years. We're all here. They should have been ready actually to start the case. They couldn't make an assumption that we would consent or that the lady would give their lead. They should have prepared properly for this case. They haven't done so. They must be directed with respect to lady by your lordship, by your ladyship, to be somebody to proceed and to argue the question of attorney-client costs. And then the lady's got draft order. The lady will either grant party and party, or the lady will grant attorney and client. Then the matter is done. We don't have to come back another time. Thank you.
And because coming up again another time is going to be costly as well.
Just costs on full costs. I mean, the lady has a discretion. One should bring this to her. They should have anticipated and prepared for today. Or at least asked us. They suggest that we should have told them. No, they want to withdraw. They haven't got consent. They should have said, why are you not giving your consent? We would have said to them, we want attorney-client costs. Then you could have prepared.
I hear you, thank you. There's one aspect outstanding. I haven't had you saying anything. You've been quiet and you are party to the proceedings. You are the fourth defendant. Why are you keeping quiet? Because it also affects you, especially with regards to what, and it goes to all of you. The application that was made by yourself, there's still issue of costs in terms of the draft order that was signed and declared as the order of cost, the court order. That hasn't been touched, and you haven't said anything. So where does that leave everybody?
Well, pertaining to the claimant's withdrawal, I mean, the fourth defendant doesn't object to the withdrawal. There's no request for the fourth defendant to pay any cost, nor for the fourth defendant to partake in that. And that's the reason why I've kept quiet. We've got, on the one hand, we've got the plaintiff, and we've got the applicant, and we've got the second, the first and the third defendant, and they are the ones objecting against one another and asking cost orders against one another. So for me now sort of to jump into the fray, my lady, with respect, I don't see any purpose of that. We abide by the court's decision.
Yes.
That's the reason why we...
No, the reason why I'm inviting you is when two parties are, the applicant and the plaintiff are moving away, and then you came in as the fourth defendant, you are a party to the proceedings, and now that you have been joined and a party to the proceedings, where does it leave you?
Yes, my lady.
That is why I wanted to have your input, because you cannot be sitting and doing nothing. Yes.
Apologies, except in the sense that I came to the party and now we've got the plaintiff and applicant that's moving away. So automatically by them withdrawing up, because I don't have any counter, there's no relief that I'm claiming. So where I am standing...
So you don't have anybody to fight with, so to speak.
Yes, there's nobody for me to fight with. So somebody threw punches and
So
I
you are in the wrong train.
Yes, and they start from
Why did you get into this
punches,
train? Why did you get into this train? What were you doing here?
Yeah, so there's
Just
nothing
kidding.
for me to do, my lady.
Yes. Thank you. Mr. Ngoleni?
No, I just wanted to say my apologies to Olivia.
Yes.
I've omitted to refer your leadership to not only the issue of the scale that is in the issue, but also the cost of, or including cost of patient by the employment of federal counsel. And normally it's within the discretion so far as the issue of costs are concerned. But also that includes whether it is justified.
What do you mean whether it's justified? They've been here all along.
Maybe they've been here all along, but is it justifiable whether they are entitled to cost of free counsel or not?
Really?
Really, man.
You.
Really.
Okay.
There are judgments where, my lady, the court refused the costs for other counsel, where they appeared more than one counsel. And my lady, I appeared alone. And was it really justified?
But it's your choice and your attorney's choice for you to be flying solo. Look at Mr. Mr. Silala. He had four.
My lady, he had 4.
And there's nothing wrong in that.
Whether, my lady, the number is not the issue. But the matter itself, the nature of the matter, whether it is, and that's what is within your leadership's discretion, as the issue of costs. It's not about how many are there.
Yes, you're absolutely right.
We come to court being 10.
You're absolutely right.
Exactly, my lady. And as a result, my lady, I'm submitting that the cost of fair counsel should not be allowed. And my lady, it's not a matter of the number. There can be 20 counsel coming, but would it be justified? Even the nature of the matter, the court considers some considerations to make, whether it is justified to grant an order where all counsel who have appeared, whether there were 4 or 10 or what, but it is within your judicial discretion to determine it. And relating also to the nature of
The nature and the complexity of the matter itself.
That's your leadership.
I agree.
That's why I wanted to bring to your leadership's attention. The fact that they've been here, it's not contested.
Yes.
It's not in dispute. And the fact that Mr. Silala had 4 counsel, it's not in contest.
Yes.
But what are the issues here, my lady, that I want to bring to your leadership's attention? is what is contained in the court order, and which I said my apologies I omitted to address your issue.
Yes.
The issue that the leadership has to consider is the complexity of the matter when exercising your discretion, whether it is justified to grant an order in terms of which more than one or two counsel are entitled to sanction, whether they be in the order. That's the issue. And my lady, when one looks at the court order, it says nothing about the way and second. And if one is to say the plaintiff is ordered to pay the cost on whatever scale, and also, my lady, the second paragraph that says the second defendant is ordered to pay. There's nothing about the jointly and severally. That will be a miscarriage of justice where the litigants are being made to pay the costs
Individual.
double.
Is it double or
It will be
individual?
double, my lady. It will be double. And my lady, if it says jointly and severally,
What do you mean? Let me tell you. You know, English is very interesting. When you say that it's double, are you now conceding that the matters have been consolidated? So there should be one cost?
no, my lady, I'm talking about the draft order.
Yes, but I'm going there. That's exactly what you're talking about.
The way in terms, the way it is structured, it's structured in such a way that
Issues are separated.
it is.
But that's exactly what I'm throwing back at you. Does that mean that you concede that the matters have been consolidated? That is why you're talking about a separation of two different matters. We've got an action, we've got an application, and why should your client be paying double?
What is being solved before the
Yes.
What is being solved before the in terms of the draft? Even if I was to concede, but my lady, that would amount to double payment. Even if I were to concede, and my lady, it would be a miscarriage of justice. I mean, it's not, costs are not meant to enrich. Costs are meant to punish, and it's within the discretion of the court. And costs are meant to demonstrate the court's displeasure in either one way or the other in terms of which one litigant has conducted himself or herself.
Is that why you're using this specific word, punish the
Indeed.
litigant?
Indeed, ma'am.
And that is where the punitive costs are coming in. So you're busy dragging these things bit by bit, bringing them to the other forum.
We were never given this opportunity to do this and to study it in depth, look at it in depth and consider it. But this is something, my lady, that we cannot just simply leave and not bring to the attention of the issues.
All right. Let me try and understand the concept of, because we normally use, as you say, in terms of the costs, one paying to absolve the other, something like that. Is that where you're going?
Yes, ma'am.
And is it in relation to both the applicants
Yes,
who
ma'am.
want to move?
Yes, ma'am.
So, say for example, if in the event
Yes,
Mr. Tsepiso Modise is paying, Mr. Leonard Medise is absolved from paying,
that's it.
and
Jointly
they should
and
not
separately.
yes.
That is so.
Even if each and every one of them has brought their own individual applications. We've got an action, we've got an application, both consolidated, but they still remain independent.
Maybe that is the fact. And that's why the notices of withdrawal are independent.
Yes.
That is
Now,
so.
here's the question. If there is a question, if there is a position, why then should you use the one, if one pays, the other one is absolved? Because they are independent. Maybe I'm lost.
Yeah.
up and I'm trying to understand. You see, when every time you say something, I drag something from there. And I need to understand why. If we have two actions, and two, you've got the applicant and the plaintiff, and they're both there on top, bringing somebody to court. And when they say, I'm moving out, why then shouldn't they be paying independently from their cases? Why should it be a problem? And then now there comes an issue of, if this other one is paying, this other one is absolved. Why should it be like that when it comes to costs? Yes.
To the notice. That was filed.
Yes.
That cost will be sought against. And my lady.
But you see, that's the thing. You are right. It doesn't say your client.
It is, my lady.
Yes.
But what is the draft policy?
All right.
The draft order doesn't say what is in the notice.
What? I hear you.
That is so.
So the draft order should correspond, obviously, with the notice of motion. What you're asking from there, it should be here in the draft.
As your ladyship is, my lady, that in itself, I thought we were past that stage where the issue, but I'm saying, my lady, the issue here is the issue of cost, including cost of therapies. And I've addressed your ladyship on my submissions as to why. What your ladyship has to consider in exercising it.
Absolutely.
And my lady, given the fact that this is what we informed that will be sought, and we come to court, we receive a draft. Your ladyship excuses herself and say, no, discuss. And my lady will pick up some of the things, and if I pick up something more, it's my obligation to bring it to the ladyship's attention. And hence I'm doing that. It's not even a matter of having to concede whether there was a joinder or what. It's the issue of cost.
Yeah.
And my lady, you brought that, you raised that whatever I was dealing with is outside what we are supposed to be doing. And what we're dealing with is what is before God now. And what my learned friend has raised to your ladyship also said, I'm dealing with other issues. Now, my lady, I'm referring your ladyship to what is before you. As contained in the draft order, as contained in the notice. And my lady, I submit that the justification for costs, including cost of trade counsel, they have the honors to say to you the fact that they were here does not necessarily mean that the leadership should overlook other aspects in exercising the discretion on the issue.
Yes, you're right.
And we submit to the leadership.
Is there a need for a submission by the party who is supposed to be awarded the costs in relation to how many people were there? No.
Yes,
for that party
yes,
to explain to the court why they need to have costs for 3 councils.
Yes,
and is the court supposed to be ignorant of the fact that, or not take into consideration the fact that this matter is before court? The court knows about the complexity of the matter, and the court has to appreciate that, but it has to be submitted physically so.
yes.
Not that I have to make an inference.
Just an inference.
All right, I hear you.
May I just come in to reply to one aspect that my friend here has touched on. The issue about the costs insofar as they relate to the plaintiff or against the plaintiff. My understanding was and has been that the issue of the application by the first defendant and third defendant in terms of Rule 30 has been superseded by this draft order. In the sense that now this draft order takes care of the entirety of the case, as my learned friend Mr. Epstein has pressed on the court. It's not about today's costs, as the court perhaps may have erroneously understood it in the beginning. Now the question is, having regard to the concessions that have been made in the draft order, the plaintiff has withdrawn and has tendered costs. The second defendant has withdrawn its application now, and they have tendered the costs as well. Isn't it that the issue that has to be determined is not about whether there is an application somewhere to declare process, penalty, and so on, or whether it's about this draft order in terms of scales? I thought that we have gone past the issue of whether the parties have withdrawn. There's a cost concession there. And hence we agreed as the parties that the issue in paragraph 2 of the draft order about whether the case is dismissed or is withdrawn has been rectified. The case is withdrawn, the issue is about the cost. We have tendered costs on party and party.
And these costs have got to do with the issue of today, not that the matter started in 2016, because there's another issue. So we are here, and this draft relates to the costs relating to the withdrawal, nothing else.
The cost relating to, I'm not too sure if that is my understanding of Mr. Epstein, because when the court asked Mr. Epstein about whether this relates to the costs of today or whether it's for the entire period since 2016, I think Mr. Epstein answered to say that it's for the entire period.
Yes.
But where does the issue of costs on a punitive scale arise? It arises from the withdrawal. Now, the question is, throughout the period since 2016 up to today, is the first and third defendant entitled to cost on a punitive scale on those numerous occasions? And I would agree with the court, in fact, and thanks for the court to the court for the enlightenment, that what prejudice has been occasioned to the first and third defendant by the actions of the plaintiff of withdrawing the matter today. And if that is the case, if there is a prejudice, the first and third defendant would highlight that prejudice to determine if they are entitled to today's costs on a punitive scale against the plaintiff. And we submit that our withdrawal of the matter should be treated as one where the cost should be paid on a normal scale. And I don't want to take it further, but I think I have said a mouthful about what we are here for. We have withdrawn, concession has been made, and now what is outstanding is a question of scale. And as I indicated earlier, my lady, this is a matter that falls within your discretion. And the question is whether my lady would be prepared, and in the interest of justice, to hear the issue of costs given the size of this matter. Whether the first and third defendant should be entitled to cost on a punitive scale throughout the entire process for over the 7 years that Mr. Epstein has been. And I would submit that if the first and third defendant would argue for cost on a punitive scale ever since then, we should be allowed the latitude to prepare for this cost argument on a punitive scale. That is my submission.
But then again, that would mean that, if I understand you correctly, that if we have to talk about punitive scale, it has to do, if in terms of his submissions, it has to do with the circumstance of today and this costs, the withdrawal, and that's where the issue of punitive scale comes in. But with regards to something else, there is no justification for the applicants to be punished for what happened previously. irrespective of whether the matter started in 2019 or 2016.
That's my submission. I agree with the court. But as of today, if it's about the determination of whether the first and third defendant are entitled to a punitive scale as a result of this withdrawal today, then I am prepared to listen to his argument, and for that, I will be prepared to respond.
All right. At least there's progress.
May I just confirm that that is also the understanding of the second defendant, that the costs are costs for
Does he hear you?
Oh, he doesn't hear me?
No, he doesn't hear you.
Oh,
because I cannot hear you.
My apologies.
So you wanted to know that these costs, this punitive costs, relates to today and no other day.
No other day. Whatever happened had its orders.
Yes. All right.
That's the issue.
All right.
Lady, this argument that's being advanced is impossible. I had to Milady the two applications which were brought. So I can refer Milady to the notices of withdrawal. The two applications brought against both Mr. Salala's client and Mr. Magdalena's client. And I flagged Milady just to make it easy for reference purposes. Lady, what I flagged is the notice of withdrawal of the plaintiff. I'm not sure which one the lady in front of you. There's the 3rd of July. That is the notice of withdrawal of the second defendant. That's Mr. Magdalena's client. And the note on 4th of July, the notice of withdrawal of the plaintiff. What do they say, the lady?
Oh, yes, they are undertaking to pay the costs for these withdrawals.
The entire matter from inception. All the only scale is attorney and client costs. They say that they withdraw the two cases and they tender to pay the costs on a party and party scale. All we're asking for is costs on the attorney client scale, including free counsel. I'm relying on their own notice of withdrawal. They didn't tender the notice of withdrawal and they're withdrawing the costs of today. Their own notice court says they tender the cost of the entire application.
Is it not a matter of interpretation as to that is exactly what happened. That is why I wanted to know, is it a permanent withdrawal or what? And that is why I was saying, do I understand you correctly to be saying that because there has been preparations for over the years, and now that today, 2023 July, they are withdrawing. So this whole process, this whole journey, they have to be punished.
And they've tendered that. They've tendered party. They would be happy if I said now, it seems they'd be happy if I said to accept their tender of party costs and two costs. Yes. And then the costs right from the start. Costs can't be taxed against parties who haven't got anything in their favor. Let me give the lady example. Leonard issues summons.
Yes.
He issues summons, and then there's a counter and he cites the defendants. The second defendant institutes a counterclaim against Leonard. We can't get costs of that. There's no list between them and us. So when the taxi master does it, the taxi master will know what to do.
Yes.
Like, it's only a question of the scale. And the reason we also attorney client costs is because they start this case, they run it for 7 years, and 2 weeks before the trial, they just withdraw it. No reason, and we're out of pocket. Because on a party scale, we'll be out of pocket. Why should we?
All right, let's look at it from another angle. Maybe that will answer Mr. Selala's issue. That, remember earlier on we said there has been, when I started with this matter, say in February, there were 3 orders, 3 judgments. Those have got their own issues.
Yes.
They've got their own orders, the cost orders. But now, the preparation, if I understand Mr. Selala correctly, when you said it should be starting from, because I don't want anybody to be confused, because it is not like there's going to be bits and pieces of, there's something happened and there was an order, or the costs were not ordered, and then there was another application, costs were not ordered. It's not about that, if I understand you correctly. It's about the fact that this matter now has made a U-turn. punitive costs should be ordered. And the interpretation of it has got nothing to do with the bits and pieces of applications, but it has got to do with the fact that having started from there, and because I'm taking from what you said earlier on, you are not being informed of why this sudden change of heart. Why now, at the last minute? Because if we did not, or we would have given them permission or consent, they were supposed to be ready, as you are also ready. And because of that sudden move, then the punitive costs comes, the interpretation comes from the fact that I started from long ago, I prepared, and then now, because of this, irrespective of whether you have tendered costs as to party and part, but you deserve to be punished because of your actions, and that's why I'm asking.
The lady, the orders the lady gave in February, those judgments, those stand.
No, those stand. That one is given. Those
does
stand.
come into play in this respect. We say that the whole of February was scuppered by all of that, and they brought 2 applications which had no merit at all, and it's all a question of delay. So we say when the lady takes into account conduct, from the start, and then a sudden withdrawal, we should not be out of pocket. And the lady's got a complete discretion when it comes to this, and there are cases which say this.
So it has got nothing, for the benefit of Mr. Salala, it has got nothing to do with anything. It has got to do with the fact that this matter started a long time ago, we've been preparing, and then we're here, and then you make a sudden change of heart, and therefore you should be punished.
And Mr. Salala could have inquired from us what is going to happen to that. What is your position? At least Mr. Angulele said, if we don't accept his withdrawal by consent, he's going to ask the court. Mr. Salala's client said nothing. He couldn't ask us, what are you going to do on this case? Now, 4 weeks have been set aside for this trial. When does Mr. Salala come back? And do we wait each day until we come back? We're all here. It's a matter which any experienced attorney or counsel can argue.
Now, if I take it from what you just said, Mr. Tsepiso Modise has asked for permission, for consent. He started first by, not following procedure. And when he was made aware, then he withdrew. And then he asked for consent. And then he said, if you don't give me the consent, I'll ask for leave. So he sorted out. Does it translate, or does it mean that in terms of paying for the costs, he doesn't have to be punished more than Mr. Leonard Modise? Or do they fall into the same category?
No, we've been talking with him the last 2 weeks. One would have expected him to say, you're refusing costs, why are you refusing costs? And we would have told him why. He had to do the writing on this. He's the one who's not in compliance with the rule, not us. He has to come to us and say, why won't you give me consent? And do something about it. He's left it until today on the basis that if we don't agree, we're asking the lady to allow him to withdraw without even telling us why he's asking for.
No, I was talking about Mr. Mangolele. I was talking about Mr. Tsepiso Modise, that, the fact that he sent a notice to say, I withdraw him because I realized that I did not ask for consent. So let me withdraw this one and then ask for consent. And he was granted consent by number 4. Because he said, if I don't get consent, I will go in and ask for leave. Now, the fact that he has done that, does it mean that he still has to pay punitive costs in terms of your submission?
Would we see this as an absolute indulgence that we have granted? As I said right from the start, we think we're entitled to turn our own time. It's an absolute indulgence that, without saying anything to us, I'm the one who approached them this morning. I said we can resolve this matter with this draft order, and I proposed an attorney-client cost. They've assumed, they can't snatch up a cherry pick. They've assumed that this order is now done for other than the attorney and client cost issue. It's not. It's a package that we offer them. You can withdraw, provided you pay attorney-client costs. At this stage, they don't have the lady leave to withdraw, nor do they have ours until we agree on this issue.
That is why I said earlier on that, English is very interesting. You ask for leave, you ask for my permission to go. If I say no, you proceed.
Yes, that is
think I should do that. Because you guys are running away from me. I should just say no.
The reason we won't proceed is if they told the lady you have an undertaking that it's a permanent withdrawal.
Yes, absolutely, yes, I agree.
That's why we won't proceed. We didn't know that before. There's only a question for us.
I can still say no. There's the word leave. You ask for leave, you ask for my permission. And if I say no, you're not going anywhere. You can nergens. Ons gaan nie bly en werk.
And then I'm ready to cross-examine the first one.
And I'm ready to listen. Thank you. I think we have canvassed the issue of costs. Mr. Nsulala, I don't think there's a need for you to go and prepare. I understand everybody perfectly. Am I granting leave or not? I see Mr. Ludava says, don't give. Mr. Ludava says, don't give.
It would be more of a relief if the request for withdrawal is not granted, because in which case, and in the event that the court says, Mr. Silala, proceed with your first witness, then I will address the court, otherwise to say my hands are tied. And in which case, the court may be inclined to strike this matter off the road, because the plaintiff would not be there, the court would not be there to listen to the evidence, and a permanent stay of this matter may be given with costs, and as to how such costs would be, it would be for the court. But I think we have crossed that bridge now. We have addressed the court on the issue of whether this is a permanent or it's temporary.
Yes.
We have covered that. The issue is the cost throughout the entire process on a punitive scale. And as I will respond as soon as my friend has addressed the court. Mr. Epstein has addressed the court to show cost why punitive scale.
Yes, that's the only outstanding thing.
That's the only outstanding issue.
But he has. Maybe you want him to repeat himself.
I thought he has, he wanted to...
Oh, no. Your issue is with regards to it was Mr. Mangolele, with regards to 3 councils. On a punitive scale, that one has been answered. We coming from, and he's taking it from your notices, that when the reading of of the notice itself, your application for withdrawal, when you because remember you're not withdrawing in terms of what he said. My understanding is that you're not withdrawing from a piece of an application. You're withdrawing from the entire from the.
I've not been heard on that, on whether there's been full compliance with the rule or otherwise. He has been hinting it. And then, well, the rule is subject to another interpretation, which I have. And
But he's saying, my apologies to interrupt you, he's saying the notices of withdrawal relates to withdrawing from the entire matter. And that is where this word is coming from.
Yes.
That because you are withdrawing, all of a sudden you're not even giving me the opportunity of telling me or the courtesy of telling me why you are withdrawing, you need to be punished. And because this withdrawal is not a withdrawal of a portion of the whole case, but it's a portion of everything. That is why it was termed a permanent withdrawal. So he's saying, it would pass like right because of that.
A distinction should be drawn between the prejudice that the first and third defendant have suffered as a result of this so-called sudden withdrawal and the punishment that the court need to mete out for the entire process, the actions of the plaintiff throughout the entire process. And I have not heard Mr. Epstein singling out each and every occasion where the plaintiff ought to be punished on a punitive scale.
But he's not talking about each and every step. He's saying, he's speaking in cumulatively. You look at where you're coming from. In simple terms, look at where you're coming from. You make a change, and then and because I was not even informed, I was not even given the the courtesy of being informed why, you need to be punished.
I am sure.
But he's not cutting it into pieces. He's simply saying a withdrawal is a withdrawal of the whole matter, and hence the word permanent withdrawal. And because of that, you need to be punished. That's all he's saying. He's not cutting it into pieces.
I really appreciate that.
Yes.
And well, I'm sure he, my learned friend, also appreciates the fact that the rules do not make provision for whoever withdraws to provide reasons. But it's a simple courtesy.
Yes.
But at the end of the day, is the question of whether the plaintiff is desirous of proceeding with the matter and whether he has tendered costs for any prejudice that the affected party may have suffered. And we have done so, I believe, and he argues that it's not sufficient. And it's a question now that lands in the hand of the court in regard to what he has said in argument. And if that is so, I would repeat that this is a matter that falls within the discretion of the court. We are in the hands of the court with regard to that aspect. Thank you.
Any reply?
I don't know if I'm arguing with attorney-client costs or not. I've got 3.5 pages of notes on the attorney-client costs. That's all. Take me 5 minutes.
I've heard all of you. We've been going round in circles, talking about the same thing. Oh, one aspect relating to what Mr. Mangolele said, that no submission has been made in relation to why should costs include the cost of 3 councils. That is the only outstanding thing.
That would have formed part of the attorney-client costs. The reason the ladies for that.
He's saying that it is only it is unfair that it is immaterial to have to refer to a number of councils representing a client or a litigant, but it has got to do with whether, and he gave an example which I agree with him, relating to the complexity of the matter, whether it was justified to be having 3 councils or 4 councils. So he wants to know why should orders, the cost be awarded to include the cost of 3 councils.
But let me firstly, we only asked for the cost of 3 council where 3 council were employed. So if there were not 3 council in the early days, we don't ask for that. And it's quite common to record 3 council where 3 council were employed. Milady has seen that since the time we started this matter, there were 3 council in court. Blackpool at one stage had 4 council in court. Mr. Mangolele has had assistance of Advocate Mayor, maybe not all the time.
Mr. Mangolele is such a genius, he doesn't need to have somebody next to him.
That's his choice. From our client's point of view, this is a matter of great importance.
The employment of 3 councils, yes.
To millions of people out there who have an interest in this matter and interest in the outcome. There are a number of issues in the matter, and it's gone through a number of the hands through a number of courts. In addition, there are volumes and volumes of paper in this matter. There are even related matters. For example, there's a company tribunal application, there's a trademarks application. Those papers have been included in this matter.
So in simple terms, this matter is very complex. It's not a matter which is
great
simple.
importance, lady, and when one looks at the various issues which were raised along the way concerning who has various rights, those are complex matters.
And those required to have the services of 3 councils, not only one.
Lady, we have really had our hands full, even with the council. And the lady also, in previous 2 judgments, the lady found that it wasn't necessary to have 3 council. The lady gave cost of 3 council in the 2 previous judgments. So we would argue for that.
Mr. Mangolele?
Please, my lady, I've made my submissions with regard to that. the leadership is now told that there are a number of documents, including the trademarks and the like. What are the issues for the litigation before your issue? And what is it? Was there any trial to say this is what we'll concentrate on? And just to say that there were part of pages to read and that does not necessarily justify the impairment of so many cards. And my lady, the fact that this matter is of public interest, it is indeed so that it is of public interest. But that is not a justification. It's my submission. It's not a justification to employ and burden clients with the costs. Even if, my lady, it's a matter of public interest. And my lady, public interest in what sense? Religious. It's not like it's an eviction of some people. We're dealing with a matter that is of a religious nature. And my lady, we should not lose sight of that fact, that the religious emotions of the very same people are affected. And my lady...
what does that have to do with cost?
Pardon, my lady?
What does the emotions of religious people have to do with costs? Shh.
My lady, we are being referred to the number of members in this competition. And I'm saying, my lady, their emotions, yes, they want to see this matter. They are very wanting to do this.
Let me ask you this. Let me ask, my apologies. Let me ask you this. Do I have to take, we've been having access to case lines. I'm trying to, come between the two of you in relation to the employment of 3 councils or 1 council or 2 councils. We've all had access to, because that's why we prepare. Our documents are on case line.
I didn't prepare, my lady.
Huh?
I didn't prepare. I'm arguing from the party.
No.
Insofar as this issue of cost is concerned.
All right, let me talk about...
draft order this month.
All right, let me talk about... When I talk about prepare, I'm not talking about... When we knew that this matter would be proceeding today,
Yes.
and we have to prepare. We have to read the documents. That's where the way preparation comes in. Now, my question to you is, should I ignore the fact or take into consideration the fact that, and you said it right, that it has got nothing to do with how many pages are there or how many bundles are there. If you take how many bundles are there, they can be complex issues, and there can be, too many bundles, and the issues are very easy. Now, having regard to that, to what is contained or what this case is all about, do I not have to take into consideration that whether this matter is complex or whether it is not complex? And if it is complex, then whether there's a justification of employing 2 councils or 3 councils or 1.
That was my submission.
Yes. So I should just, because that's what I'm coming from.
That is my submission.
That because I know what is happening here, I have to make, a decision in relation to what I have before me or what I see before me, whether it justifies the employment of 3 councils or not. So we are sorted there.
We are very much sorted.
All right.
This is the point that I've raised.
Yes. But now you said he must make submissions. So that is why I'm inviting you to say, do I also have to ignore that, or do I have to take into consideration, because I've got access to case line. And that is why I'm repeating myself. I like repeating myself so that you be on the same page. We prepared. We knew why we are coming here today. And they prepared. You did not prepare for cost anyway,
That goes
but
to the
yes.
issue of what the leadership was saying, that should
Yes.
be confined to this.
Yes.
That I don't have any.
Mm.
The
So
issue
you-
of cost should be confined to today.
So you have a problem with the language of saying, even if these costs, it's a punishment from having started from a long time ago.
That's where I have a problem.
No, but that's not the interpretation. The interpretation is, we come a long way, and now we're making a U-turn. You must be punished. It has got nothing to do with the bits and... Remember, I gave you an example. It has got nothing to do with the bits and pieces of what is happening.
Punished for coming a long way and... Is that one of the issues that your leadership has to consider in exercising a discretion?
Yes.
Coming a long way, my lady, there is too much to explain.
Yes.
And I tried to get to that, my lady, I was stopped.
Mm.
So, but if my learned friend wants to say we come a long way, I come a long way. He started with this matter of 2019. I started with the matter in 2016. And my lady, that's why I'm saying each and every aspect of it has its own control.
Mm.
If
Yes,
my
I
learned
agree with
friend
you.
was saying we come a long way from 2019 or from when we started the case management and the like, well, I don't understand. But you can't count the 7 years where you're not even impeached. In where the action also was not even impeached. It was only the application. So, my lady, to refer to coming a long way, it's somewhat unfair. Preparations were not made during those 7 years. The preparations that your leadership is doing,
Talk about now.
it's for now. And as relationship, my submission is that we concentrate on the issues that are before
Yes.
as relationship.
Interesting morning.
I employed 4 counsel. I'm very shy. In fact, I don't want to.
You needed an army. And now you're running away from me.
I could not enter the debate about whether 3 counsel or 2 because if
You're in the same boat.
If the daggers are to be pointed at me, I may not have. I employed 4 counsel. So
Don't
I
worry,
am
Mr.
not-
Mangolelo will protect you. He's right next to you. All right.
Lady, we made one amendment to the draft order, the lady made an amendment, so the hand up one, that is what the report permanent.
All right. I also wrote on mine. It's okay? Oh, you typed. Okay.
So we just wrote it as well.
All right. I also wrote them. It's okay. Thank you very much. I don't know whether to say this has been a difficult journey or to say it has been an interesting one. And I see Mr. Ledwaba is smiling right at the back. It means it has been an interesting one.
I was just asking him if there's anything that himself on that he wouldn't want to give me a lashing outside court and say you didn't consider.
Let us agree on one thing. There are people who are using the word, let's agree to agree. I want to borrow that. And that is why I engaged you in relation to the fact that do I have to take into consideration the fact that I must appreciate whether the matter was complex or not. So let us agree on one thing. We cannot run away from the fact that this matter is complex. One does not have to be a genius to see that. And you see that when we're preparing documents, when we were preparing obviously for today, not having known that Mr. Mangolele would run away from us, or Mr. Selala would run away from us with Mr. Withdrawal. But facts are facts. The point is, this matter is complex. And I want to believe that, not talking about Mr. Epstein, I want to believe that when parties employ or when attorneys employ a number of counsels, like you have a partner right in front of you, right next to you, it is not about the number of pages. It is not about how many people I can afford as an attorney, but it is about whether this matter justifies for me as an attorney to employ people who will handle it, or the number of people who can handle it, because it's a complex matter. Because as you said, as you rightly put it, clients should not be suffering for making payments for others where there's no justification. And that is why parties normally employ 1 or 2 or 3, depending on the complexity. And without repeating myself, I'm of the view that this matter is complex, and it justifies both parties. That is Mr. Mr. Selala and Mr. Twala there, for them to have employed 3 counsels and 4 counsels, respectively. Now, with regards to the costs, I'm still coming down here. With regards to the issue of costs, as to whether costs should be costs as in between party and party scale, or in whether they should be punitive costs. I've listened to all 3 of you regarding the submissions that were made. And I've also considered what Mr. Mangolele has said. That is not even necessary, or a party is not even required or forced, so to speak, to explain himself as to why he's withdrawing. Even though Mr. Epstein is saying, as a party out there, as a colleague out there, I was not informed about the sudden change of heart. He said it's a courtesy. I agree. Whether this permanent withdrawal, even though it's happening today, I cannot take it in isolation. I know that I was not here from the beginning when the matter started. I was only roped in this year. And I've listened to all parties regarding the interpretation, or what became a confusion as to whether the costs on a punitive scale means because a party has permanently withdrawn, and the attitude, I'm borrowing these words carefully so, the attitude with which this matter has been taken by a party who is withdrawing, whether that attitude or whether that behavior deserves to be punished or not. Both Mr. Mangolele and Mr. Selala have repeatedly said it is a discretion of the court, and I agree with you. Does the withdrawal or the sudden withdrawal by both parties, considering all aspects, and looking at the entirety of the matter and what has been happening, and how Mr. Leonard Modise in particular are mindful of the fact that, one, he did not comply, hence there was an application in terms of Rule 30. And once that application was made to say remove in terms of Rule 30, and he had not done that, Mr. Sepiso Modise saw it fit to follow procedure and comply. Even though it was late, but he did comply. He did not get consent. He withdrew his application. He asked. He put in another application, which was a request to be given consent, and he was given by the fourth defendant. And he said in his application, if no one responds, I will ask for leave. And that is why Mr. Mangolele is here today, and that's exactly what he was doing. He received consent from one party. The same cannot be said for Mr. Leonard Ledwaba. He has not done anything. Oh, my apologies. Protect your surname. The same cannot be said for Mr. Leonard Modise. He made an application which was not in compliance with the rules. He was requested to correct that mistake. He either failed or he refused because he has not done anything. But his attorney is here. The question is whether that kind of a behavior should be punishable with punitive costs, and the answer is absolutely yes. Non-compliance with the rules, especially where a party says, please comply, and you ignore them. I cannot find any reason why he should not be paying, or he should not be asked or ordered to pay costs on the punitive scale. Mr. Mangolele, earlier on, you indicated that the notice of motion, or the prayers in the notice of motion, are not what has been or what is contained in the draft order. The draft order, let it be, clear about one thing. This draft order, as much as all the parties have been, making submissions to and fro regarding whether there's a proper interpretation or whether there's a proper reading or understanding of what is contained in these two documents, being mindful of what Mr. Epstein has said earlier on, it became a confusion regarding whether it should be a punishment from where the matter started. It's not about that. But the understanding is we have, and it's not even about we have come a long way. The simplicity of this submission or the understanding is that abandoning the whole matter from where we are, or up until where we are today. As it relates to what parties normally refer to as a party being punished. If one looks at that, it doesn't fall far from what I said earlier on about Mr. Leonard Modise. It's one and the same thing. And there should be an understanding that when we talk about costs in this matter, we talk about one thing and one thing only. These costs have got nothing to do with what happened previously, because the application itself is very specific. I'm withdrawing, and I'm withdrawing permanently, and I have to pay costs. The orders that have been made previously, they do stand, and it will remain like that. Whether they have been honored or not, I don't know. It's up to the parties to take care of it. And those orders cannot be dragged in to come here at what we are today, or where we are today. So in essence, everybody's talking about the same thing. Permanently withdrawing from this complex matter, which in my view I say is complex, and whether a person or a party is entitled or deserves to be punished, which I have already ruled in terms of, in respect of Mr. Leonard Modise. He deserves to be punished. And I said earlier on, I'm going to repeat myself, non-compliance with the rules, his conduct up to this point. One must appreciate the fact that, with taking regard to what Mr. Epstein has said earlier on, that is why we have been engaging for such a long time, not wanting to be confused that this matter is coming from far back in 2016 or 2019. It's not about that. But if I have a draft order before me, which has to be declared an order of court and by agreement between the parties, and the draft order does not specify that this matter, these costs that we are asking, should be coming from far back as 2016. It cannot be interpreted like that. It is what it is. The point is, there should be costs in relation to this. And there are costs that are going to be awarded. To be on the same page with everybody. The issue of whether the costs, I'm talking about Mr. Mangolela's client, of whether he should be paying, he should be ordered to pay the costs on a punitive scale. Once again, the same principle will apply. And I appreciate the fact that he had tried, even though very late, he had tried to correct what he was supposed to, or what he should not have done in the first place, and try to correct the rules. As I understand Mr. Epstein, as to whether, even though he has done that, whether he deserves to be punished as well, given where we are today, given his conduct as well, of how we reached this destination today. Considering everything before me and all the submissions that have been made and the arguments from Mr. Mangolele, it is my view that punitive costs should be ordered against Mr. Tshepiso Modise. Now, this draft which I will now pronounce on it, but before I do that, I want to reflect back at what happened before. And I say this, I want to say this, what I'm about to say, I want to say it with due respect to all the parties concerned. I do not wish to bring what happened previously into this aspect that we are dealing with today, but I deem it fit to have this issue brought up. And the reason why I do that, it is because of the parties that are involved in this case, how the matter was, or how the matter was considered. When parties come to court, sometimes they get lost somewhere. It's natural. People get lost along the way. Whether they are aware that they are being derailed, it's another issue. But I know for a fact that when legal practitioners are appointed, or they are being, people normally use the word to ordain. I don't know what that means. Maybe people from church can tell me what it is to ordain. But anyway, when people are being admitted, when practitioners are being admitted, we always take an oath. All of us take an oath. I was taught that my duty, or the first duty of a legal practitioner, is to the court. First, to the court, and second, to your client. But it is regrettable what happened in this case. And I'm bringing this up so that even in other cases, when we prepare as parties, we should not get ourselves tainted. We should not lose sight of who we are and where we are coming from. We should not lose sight of the mandate that we have been given. We should not allow ourselves to be dragged into muddy waters by our clients. We should not find ourselves being in trouble or being looked at by other people in a negative way. We should not take the instructions of our clients personally. When clients have got issues, let them be their issues. All you can do as a legal practitioner is to advise and proceed. Advise and take instructions. But when those instructions are tainted in between, then it becomes a problem. And when those instructions are tainted in such a way that you lose sight of who you are as a legal practitioner, it becomes a problem. I say this being, referring, I'm going to sneak in something. That is why I said I want to reflect back on what happened. It's a pity that it's the end of the journey, but it has to be said. A few seconds ago I said, as parties or as legal practitioners, let us try and make sure that we know how to separate issues. Because if we allow ourselves to be tainted by our clients, we'll get into trouble. I'll give you an example. It is not a secret that there were allegations thrown of somebody sanitizing somebody. My concern is that even when we end this road today, damage has been done. Not to me personally, yes, to me personally, but it worries that the judiciary should be dragged. This bench, the entire bench, should be dragged into the muddy waters. And that is where I was saying, as legal practitioners, we should know who we are and why we have been given a mandate and why we do not have to take personal, what clients are doing. When you see as a legal practitioner that clients are having problems, don't get involved because it will lead us into trouble. Now here's the thing that I wanted to bring forth. As practitioners, we know that we are always supposed to be preparing. We prepare, we over-prepare, and we over-prepare. You have to know your case in the palm of your hand. Some people say, I was dreaming about my case. And when somebody says that, then they know exactly where they are going. They have thoroughly prepared. You cannot take them by surprise. Now, when our brother here brought an application, when there were allegations about the bench, the allegations were there out there in the media. And please don't misunderstand me. I said earlier on that I wanted to bring this to the fore so that people can understand that we are in a noble profession, all of us. Being a legal practitioner, being on the side of the law, it's something that is respected by everybody. People take all legal practitioners with the highest, they look at them with the highest of dignity and respect, and that should remain the same. It should not be tainted, it should not be going the other direction. One of our colleagues was not here the other day when the application was made. And I don't think, Mr. Hana, you were also here. I think you came right at the end when there were allegations that were made. That the allegations were made by one of the legal professionals that the bench has been tainted, it has been bribed. Only to find that those allegations were made in an affidavit under oath. Doesn't end there. Mr. Epstein previously used the word perjury, because when you say something under oath and it's a lie, it means you perjure yourself. The person who was doing these allegations is not just an ordinary person, he's a legal practitioner, and he made unfounded allegations which saw this, the bench as a whole has been corrupt. That should end. And I say it should end with one reason and one reason only. That Mr. Maluleke, when he made those allegations, he said he was being informed by somebody in November 2021. And during that time, the case was not before court. This court in particular. Became involved in May 2022. Now, question is, when allegations of corruption and bribery came into effect, the case did not exist, in simple terms for people who don't understand. Then how can a legal practitioner go to an extent of making an oath, writing an affidavit, giving it to somebody? He knows the law. He knows the rules of ethics, and he lies about the judges. And in particular, he says the judge has been bribed. He makes those allegations being specific. Somebody told me in November 2021 that the judge was bribed. Lo and behold, the very same judge is only appointed in May 2022. One can understand the impact of it. Where do we lose it? Where did we lose it? Where did we get it wrong? To have a legal practitioner doing something like that. It is not right. It should not be allowed. I've quoted cases previously from the Supreme Court of Appeal and from the Constitutional Court, which says that when you do that, when you attack somebody's reputation on a personal level, you are defaming them. And now look, unfortunately, we are not going to get the answers to anything. And that is why I said, I'm saying this because it is said that when a party that was representing Mr. Leonard Modise brought this application, they brought an application which was based on the information that was given to them by this very same council, who lied under oath, who destroyed the lives of people, who tainted the judiciary. We are where we are today. Look at what happened, what is happening. There's security everywhere. Look at Mr. Mangolele. He's got security. And it is because people are not safe. And this should not be happening. We need to prepare and thoroughly prepare. But now to have a practitioner standing before court, making an application without even preparing, or making an application being aware that I'm making myself a party to a lie, to bring the judiciary into disrepute, it's very sad. It should stop. I said the other day, not in my name. It should not be allowed. Because when people see judges out there, or lawyers, they see they are corrupt, which is not true. I said previously that, this affidavit contained personal issues. You can see that from the reading of the documents. There's a personal vendetta between the two parties. There's huge animosity from the reading of the documents. But the person who's supposed to be knowing right from wrong and following the rules of ethics takes the court and turns it into a playground for scoring a settle, for settling a score. It should not happen. It should not happen. Courts should not be a playground for people who've got their personal issues brought in here and makes the court, I don't know what to call it, but it's wrong. So when we advise our clients, let's advise them accordingly. Let us not find ourselves in the middle of people trying to use you to settle their scores, and you fall for it, and you go to court, and you present a case, which is, you can see clearly, it's based on a lie. And to make things worse, you make a concession. You say, I can see this is a lie. And the question is, why then do you proceed if it's a lie? Why continue to make that application if you can see that everything is a lie? It is wrong. It brings the issue of ethics into play. That is why I said we all take an oath without fear, favor, or prejudice. We shall be honest and be guided by principles. We shall be honest and be guided by rules. But in the process of doing that, when somebody gets derailed, when somebody decides to take a stand with or make common cause with their clients to do what is wrong, and they see it and they fall for it, or they agree to assist the client, to turn the court into a playground, that should not be happening. I'm not going to name names, but I know that the parties understand what I'm talking about. And I say this with due respect to all parties. Mr. Salala, you know exactly what I'm talking about.
Indeed.
Yes. Yes.
Yes.
But let us detach ourselves. When client wants to use us, we should say no. And that is why I said when I started, when we take an oath as legal practitioners, we should know that our first duty is owed to the court first, and then to a client. That is why a practitioner would just give advice to a client. As to whether the client takes that advice or not is another issue. But don't be dragged into it. Don't be dragged into the mud. And please don't ever use the judiciary or the bench to fight private battles. We've been talking about costs now. There has been applications and applications and applications. 3 applications. And where did that lead to? Costs were ordered against the party. And for what? And because of this very same person who came with a lie that one of the judges there was bribed, when he knew, or when he decided to just use people who were blinded by him and say, go and fight, there has been bribery. Unfortunately, his team did not see that, but this does not tally. As one of your counsel said, there are discrepancies, in terms of when things happened. The matter starts in May 2022, and he talks about bribery happening in 2021. Common sense tells you this can't be right. Stop making allegations. Stop defaming people. I think I've said my piece. People appreciate, I understand where I'm going and where I'm coming from. Now, back to business.
On that note, my lady,
Yes.
may I just ask to be excused to my opportunity just to respond to a call of nature?
Oh yes, please, thank you. The benefit of not flying solo.
I have the members of the SAPS.
Anyways. Mr. Epstein, Ms. Koza, we have the draft and everybody's happy with it?
Yes.
It's a permanent withdrawal?
It's a permanent withdrawal.
It's a permanent withdrawal?
The cost maybe it's in the determination we can write it on or leave it to the lady.
Mr. Epstein, please don't hide behind that thing anymore. You must just move next to Mr. Osborne. I said on a punitive scale. No, I said on a punitive scale.
That was the last word.
Yes. No, I know you want to be sure. It's not like you did not hear me. You heard me very correctly. You just wanted to make sure that you heard me correctly. On a punitive scale, Mr. Epstein. Can I? Yes.
And just in terms of rounding off the draft order, your ladyship had a debate with my learned friend Mangulele about the joint and several nature of the relief. And I'm not sure whether your ladyship or which way your ladyship was going. I would submit that the relief, the orders against the parties in 2.1 and 2.2, there should be perhaps a 2.3 saying the costs
Jointly and severally?
are joint and severally.
No.
Oh, okay.
Absolutely not.
I just wanted to remind your ladyship, in case your ladyship was wanting to put it
No.
as
I heard myself when I was saying it. I was there when I was saying it.
as the board pleases.
Absolutely not. That is why I engaged Mr. Mangolele to say let's understand each other. There are two actions. There's two issues. There's action. There's application, and I don't see any reason why, and there's no justification as to why I should do that, because they are both independent, and it cannot be said or it cannot be concluded that one is paying to absolve the other one, or as the word that you was using. No. So it stays as it is.
I just want to find out maybe if the notification with regard to
The what?
dismissed, I think it
No, yes, I just said it.
removed and replaced with
Yes.
withdrawal.
An action instituted by the plaintiff, Mr. Frederick Leonard Modise, Hultima Modise, under case number 14038 of 2019, as well as any counterclaim that he has under case number 11935 of 2016, is withdrawn permanently with costs on an attorney and client scale in favor of the first the third defendant and the 33rd respondent, including the cost occasioned by the employment of 3 counsels. The same will read, the paragraph number 2.2 of the draft reads, the application of the second defendant, Mr. Tsepiso Samuel Njele Mukhulu Mudisa, under case number 11935 of 2016, as well as his counterclaim under case number 14038 of 2019, is withdrawn permanently with costs on an attorney and client scale in favor of the first and the third defendants and the third respondent, including the cost occasioned by the employment of 3 counsels.
Thank you.
Now that has been done, anything else? Did I leave anything behind?
Now the lady has, you find yourself for the word. Nothing else on our side.
I would require you to call your witness.
You don't need a witness now. Thank you, lady.
All right. Is there anything that we left behind, or are we done for today?
My lady, I just a point of clarity on the order. As regards to point 1, paragraph 2.1.
Yes.
It refers to the 33rd respondent being ordered to pay the costs. And
You had issue with the 33rd respondent.
I had issue with that, my lady. And the 33rd respondent is not a party to the action, but the third respondent is. And my lady, the 33rd respondent.
Let me go to my case line. Yes, okay. Let me take it from one of the, let me take it to one of the judgments. It's going to be easier that way to see the parties on top. Now let's hear it. Your client is the applicant
Indeed, ma'am.
on 1195.
That is so.
Yes. And on the other side, on the 140. And let's talk about, let's be specific. We're talking about the third defendant,
The third defendant.
which is who is the 33rd
Who's
respondent.
The 33rd defendant in that application. But if your ladyship is going to order that the 33rd defendant, who is also a respondent, who is also the third defendant in the action, be ordered to pay costs, then, my lady, in that regard, I would say that it would be appropriate for your ladyship's order to say, since it appears again with regard to the application of
By the applicant, yes.
to say that if your ladyship wants to leave the orders is, then it should be jointly and separate.
No, I said no.
That is so much. Then it means the 33rd respondent.
Because it does not apply to your client in terms of the
It does not
actions.
apply. Yes, your ladyship.
Just to picking up from what my colleague has just indicated, I'm not too sure if the 33rd respondent, in fact, if the plaintiff should be liable to the 33rd respondent costs, if
Say it again. If
I'm
you are,
not too sure if this is correct, because the 33rd respondent is the same party as the third defendant, if I'm not
Yes.
And then in paragraph 2.1, it would appear that the court are ordered against the plaintiff, against rather in favor of one party twice. Because the first, the third defendant and the 33rd respondent
At the
seem
same
to be one and the
It's
same.
one and the same person, yes.
So I think there has to be a severance or cutting out of the third respondent in paragraph 2.1. Because it's one and the same party.
Let's see if your colleagues are getting it right, not getting confused. Ms. Kosa, please explain to him. Please explain to Mr. Epstein what.
The 33rd respondent was joined by Judge Rolinga on 14 March 2018.
So obviously he appears on both.
Surely it is a matter for the taxing master. If there are no costs in favour of these parties, then there's nothing to tax.
Sorted? Sorted?
I did not get him clearly because if the 33rd respondent is one and the same party or as the third defendant,
No, he's saying, my apologies, he's saying that it's two different matters, and then the 33rd respondent was wrote in terms of a court order of Judge Raulinga. So if that is the issue or that is the problem, the taxing master will take care of it. That's what he's saying. Yes.
Because we are not the applicant.
Yes, because remember, even the taxing master has got a prerogative of who he wants to award, in terms of the cost. How, I don't know what scale they're using or whatever, or how they separate the issues. Then they've got that, they've got the expertise of knowing who to give and who not to give. I don't know, I'm not involved in that. I can only make an order, but they, yes. Yes.
To avoid the confusion at a later stage. Because if it is considered that it's one and the same party, then why then should the plaintiff...
No, he's saying that they are two different people. Am I correct in saying that? Yes, he's saying they are two different people. Because there's a specific court order roping in the 33rd respondent. Third defendant and 33rd. Yes. So if that is the case, then you agree with him.
Yes, it's the same parties, but lady, in the notice of 2.1, is the action instituted by Levin, who said under case number, as well as any counterclaim he has under 11935 or dismissed. If he's got a counterclaim, then
because he himself,
there'll be no cost.
Yes. Because remember, that is also his application. I'm withdrawing my action on any counterclaim that I have.
I don't remember we having a counterclaim there.
No, but that is, yes, no, but remember, that is your application. Yes. Your client's application says, I'm withdrawing my action and any counterclaim that I have.
Yes.
So this draft order, this paragraph 2.1 comes from your application.
Yes.
It tallies with your application. If you don't have a counterclaim,
Yes.
and the taxing master will see to it. But because you are telling us that you have a counterclaim in the application, then we have to pay the cost. That's where Mr. Epstein is coming from. And I agree with him. Yes, the master will take care of it. So I agree with Mr. Epstein. Because it's not coming from nowhere, it's coming from your application. You are saying, I'm withdrawing the action permanently in terms of action and the counterclaim in terms of this application. So you're withdrawing from two issues. And because you brought that, he's responding to you to say, because you are telling me that you have an application, you have an action, and you have a counterclaim in the application, I will go the route that you are going. Yes. Understood?
It will be taken care of.
Absolutely. Now, are we done? Everything okay? Are we done? All right.
Thank you.
I've got patience, Mr. Mangolede.
Thank you. So you are. So you are.
I know.
Very patient.
I know.
That's your relationship.
Thank you. Mr. Osborne, ever since you came down here on day one, you've never said anything to me. You have never said anything to me.
Lady, I'm unable to take that any further. May I seek the postponement?
Please, granted. I like it, granted. When can you come back tomorrow? Thank you. It is so granted. Thank you. I must say it was nice working with all of you. It has been a rough journey, but it was a nice one. And our fourth defendant, you, in Zwana we say was Parapara. He came at the last minute. And then he just fell on the last minute. I would have loved to work with you. But on a serious note, thank you to everyone. Thanks for your time. Thanks for having gone this journey with us. And to the people in the gallery, I would also want, and the members of the press, I want to thank all of you. You have taken your time, some of you have taken your time off from work to come and hear this. We previously talked about the interests of the members of the church. They want to see this matter finalized, and it is finalized today. And I hope there's going to be peace. There's going to be respect amongst each other. There's going to be love amongst the members of the church, irrespective of where they are coming from. Respect, respect, respect. Now that everybody has got closure, I hope those who sneaked out of their workplaces without even informing their employers are not going to get into trouble. If you get into trouble, please tell them that I said they should just forgive you for today. And please tell them that you are happy people because the journey has ended. Life goes on. So thank you to all of you. Thanks to the attorneys for the journey that we have. And thanks to Mr. Ledwaba. Mr. Ledwaba never says anything. He's always smiling. And every time he smiles, he just ducks and just go underneath the chair. Anyway, thank you very much. Oh.
All right.
Thank you, Regent. Now I'll take this. Don't mind me. Thank you, your excuse. I do this all the time. Don't mind me.
mufelo ya buso ya tawina kipenya. Kabano ya mufelo ya buso ya tawina kipenya. Kabano ya mufelo ya buso ya tawina kipenya. Aulanta Jerusalem, 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 Kabano ya mufelo ya buso ya tawina kipenya. 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 Aulanta Jerusalem, Aulanta Jerusalem. Seba selemo moto ke moya o halalela o dutse botsa o re tuletse tsohle ka moya wa gage re seba di phiri le makuno ka moya ona wa gage ona moya o dira masho ya ka matola ona moya o dira masho ya ona khoro ye ka matola le gore re bapata batho ba bagolo. Tshano ya bofelo ya puso ya tau ena ke phela.
It says, the sitting comforter, right, shall anoint his successor spiritually, right? We've said it many times, right, to say we have recognized our comforter, successor, MG Sandlana, as the one, because we have noticed the spirituality in him with which his predecessors have said it, to say the one who's going to take the throne, you will notice him by 1, 2, 3, 4. That also is in line with the custom, tradition, things that he knows others don't know. We don't even know. So that person, that's how, in a nutshell, there are many things that we can mention. For example, he has performed the faith healing ceremony. 2 of those faith healing ceremony before the 2 could perform one. He has just done the 3rd in April this year. So that shows this, he is the anointed one. That is drawn then from this preparedness spiritually that is stated in the Constitution. So that's how we recognized our current leader as the leader of the IPHC.
Let's do another level. Say 2 if you guys are
Okay, yes.
what can we do?
All right, I am rolling.
Re itumetse thata mabapi le tshwetso e nkilweng ke kgotlatshekelo le hona ka gore dilemo tse fetileng tse dintsi tse di supileng re lwana le taba yona e ya ketapele ya IPHC yaanong mo re leng mo teng ka se sebaka re itumetse ka gore kgotlatshekelo e nkile tshwetso ya gore taba e fedile a gona o mong yaanong a lwelang go nna moetapele wa kereke ya IPHC. Yaanong IPHC e ikemetse ka bo yona ke yona e tla announceang gore moetapele wa yona ka semmuso ke mang, empa re ntse re itse gore moetapele wa kereke e ke mang, ke yena ntata rona tao e khula le bula Juda ntate MG Sandlana, ke yena moetapele wa kereke ya IPHC. Sijabule kakhulu ngalesinqumo esithethwe inkundla yamacala namhlanje ngalendlela ngokuthi iminyaka eminingi cishe edlula isikhombisa silwa nalendaba yobuholi besonto beInternational Pentecostal Holiness Church. Namhlanje sijabule kakhulu ngoba ujaji wethu ukhonile ukuthatha isinqumo sokuthi leqala seliphelile ngoba laba abafo ababili uLeonard Modise noThipise Modise babuqishile lenkambiso yabo yokuthi balela ukuba ngabaholi baleli sonto. Ngaleyo ndlela kusho khona ke ukuthi isonto selisolo lilodwa manje yilo elizokhuphula ukuthi umholi walo ungubani. Ngaphandle kwaloko sisho ukuthi umholi wethu uye ubaba wethu ingonyama enkulu Juda ubaba uMG Sandlana. So you assume you are multilingual?
Yes.
Withdrawal permanent. Ora nkasa khala kiri ke nna Mohammed. Armando kupatologi ya Songa kana ronari international Pentecostal Holiness Church Iphc original yata ya khulal Dodo armamele re thoma fase gore ba utla kere re taya khulal le khula juta Hallelujah. Isungula hansi. Iringala leikulu ya rixaka ra Juda yi hlurile. Rena ari makaka ra tseba ri tawu ke leshala la nto hola loko ku ri hina vana va yena a hi hlamali hikuva ha swi tiva ku ri nghala leyikulu ya rixaka ra Juda i secha ra khale arali hu rine vana va ndawukulu ya rixaka ra Juda a ri mangari ngo ri ya tiva ndawukulu ya rixaka ra Juda ndi lisole la kale vana va porkoto nene munnaole le munnaole le kereke akere yona vanna vale va ri ba withdraw mo leadership battle permanently hi ta tsundzuka ku ri ka nandzu lowu a ku ri n'wanuna luya na n'wanuna luya ni kereke se leswi nuna luya na nuna luya va nga tshika ku sala kereke va ka swivumbula swa ri ho hola munna na kereke zwino arali hola munna va xiri va ko tibvisa va sala kereke
that it has put down today on the background of the two contenders of the leaders of the church permanently withdrawing. That therefore leaves the church no to say who their leader is because they too have permanently withdrawn from the case. That makes us happy. We'll be able now to move forward. We know where we stand. We know where the church stands. And then very soon, before the end of the week, we'll be holding a media briefing indicating to members, those who are not part of the church, waiting for this matter to be resolved. Now that it is resolved, at least we have a way forward.
What does this mean for the church? Of course, we've seen the sons withdrawing, but who then becomes the rightful leader to lead the church forward? Is there a council that will recognize who becomes the leader of the Iphc going forward?
Yes, look, on the 12th of January 2017, there was a council that was elected. And on the 4th of February 2017, subsequent to that SGM, which, by the way, was ordered by the court, and there was an executive committee that was appointed. So that executive committee, from around about August 2018 to the 3rd of November, when the resolution was made that the church recognizes his great successor, M.G. Sandlana, as the leader of the church. Hence, Leonard Modise the following year contested that he cannot be the leader, he is the leader. While Tsepiso filed that application in 2016, which the church said, no, you can't be the leader of the church. Hence, they too went and formed factions to contend this leadership. Now we are saying, now that they've withdrawn, we have a leader that they've been contesting to say he is not a leader. It is Leonard who said he is not, with the church having recognized him in November 2018. So the church said to Tsepiso, you are not, early in 2016, following the passing on of Comforter M.G. Modise.
But is Ntate Michael Sandler, who's the leader of the Jerusalem Church branch Iphc,
yes.
Iphc, is he the son of the late Ntate Bishop Modise? What is the process there? Can anyone just ascend from any senior leadership position. Is he the son?
Look, it's a pity that this question keeps cropping up because the church has got nothing to do with the biological lineage as to who should take over after the sitting comforter passes on. That question is irrelevant. The relationship we have with the leader of the church has got nothing to do with the biological profile, his descendancy and where he comes from. It has got to do with our spiritual association with him. He's God sent, it's got nothing to do with a biological profile. Therefore, the question as to whether he's the son or not is irrelevant. It's unfortunately, had this case started today for the next 4 weeks as it was planned, we were going to show evidence that the two predecessors, both the founder and the comforter, did say this is not a family church, this is not a Modisa church. Not once, not twice, more than 3 times. We had those exhibits, those video footages where those predecessors were saying that themselves. So the question of whether it's the biological son or not is irrelevant. I hear that there's a DNA issue, as it were. That DNA, it was brought by the former executors, sent by the family to say, we hear the rumors that there is this person who claims to be the son. He's not claiming, right? And we want him to undergo a paternity test. He obliged. There was a court proceedings. There is a judgment that was handed with cost against the former executors. And in that, 2 things only, the judge said, and which is derived from the affidavit that our father proposed to. It says, there's no need for our father to undergo paternity test because he's not claiming any side from the estate. He renounces his right because his father, when he prepared him for this spiritual role, he said, do not look for worldly things. I'm sending you to look after the church and pursue your spiritual obligations. Right? So in that order, the judge said, there's no need for this person to undergo a paternity test because he has renounced his right. And in that judgment, it says, clearly, it shows that they are using this so that they use it in this leadership. From there, he's not a biological son. So therefore, that judgment, it is not our father who said, no, I don't want to do the DNA. He challenged them to say, under which circumstances do you want the NDA? I mean, the DNA. So we ended with that judgment, which I have shared with you already.
What happens now? Are you going to be speaking to the other factions of the church to reunite the church and stop what has been going on for the past few years?
Yes, what's going to happen now, that we are the church, is upon them. Now they've withdrawn. They are more than welcome, right, to engage us, to say, now that we have withdrawn, you are the church, where to from here? But for sure, what we know, and I hope they will oblige, they will be compliant. Now that we are here, they've abandoned the leadership of the church. In essence, they should be vacating all the church properties, right? And in that, it is them that you say, look, we've abandoned this, we don't want to be leaders of the church anymore, but then where do we go from here? And then the church council will resolve and take a decision from that. But as it stands, now that we are here, the church says, or will say, vacate all the church premises now that you are no longer contesting the leadership of the church. You are just like any ordinary member of the church, unless their followers decide that they are the leaders of their own formations.
Thank you very much, of course. So it seems as though those are quite strong words coming out of there. What happens next? It seems those particular branches of the churches that are breaking apart from the Jerusalem Iphc branch will now be maybe requested to vacate those premises. This is something, of course, the Jerusalem church will be discussing. Now that we understand that the sons of the late Modise have permanently withdrawn from this court case where one of the sons, Leonard Modise, wanted to be declared as the rightful leader of the church. It will be interesting to see how really this unfolds.
Yingiselani khombo ileri kona la xikarhi ka nandzu lowu ku va ni vanhu lava va nga magqweta ya mavunwa va nga tsala mavunwa se jaji u ri tano u ri va fanele va ta hlamula mavunwa lava nga ma tsala abathetshelese khano mulandu hoyu obona varamafhungo kana varipoti va mafhungo veo vachiripota mafhungo amazvipi asiyone zvino vana vantu vafuna kuda vatalutshedze ala mafhungo ava vangozvipa one
la dihopola dilora tsela tša maka tša di-third force yake dilora tsela di boletše maka under oath ba re ba tshwantse batle ba bolela gore ba ralokelang ka molao ka gore ba saine gore bona ke boramolao ba tla di a tokafela
mama tundruka magqweta lama ya third force hi wona lama nga teka timhaka va yisa ka vatswari va mahungu va vulavula hi jaji va vulavula mavunwa se jaji wu ri avate va ta hlamula leswi va nga swi tsala va vumbura havalani va third force musi va ta n'wala nga fasi ya muano nga affidavit va tshi khou ṅwala mazwipi zwino phanḓa mulayo jaji uri vha funa uri vha ḓe vha fhindulele mazwipi a vha ṅwala fhasi ya muano
bona batho bale a ba tlo seka fela dilora tša rena nako ya kaofela ne di bereka ga di tlo patala ke rena di patala ke bona
ma vona magqweta lama ma nga tenga nandzu lowa hina ku fika namuntlha a va nge hakeriwi hina vona lava va ku vulavula mavunwa lawa jaji u ri a ku ve vona va hakelaka ku ta za ku boxeka na swikhwama va vona a ti ri mulandu wononi va va ri na voramilayo ra ri ku va xumisa a ri ku chimbila nawo zwino jaji u ri a si rine rina ra to badela milandu heyo hahalani veva va ku ri chimbidza kha nyendo hedzi ti vone vana va tota va badela milandu ya malara ashu
gore banna bana ba babedi ne ba re ke bona bo moemedi le di-third force tšela bao patala dilora tša ene rena re berekišitse ba rena tša di-cheap line tshwantse ba patele
ya vavanuna lava vambirhi a va ku hi voho vayimeri na vona lava ya va third force va ta humesa mali yo tala phela a yi tirhisi magqweta ya ku chipa ni hi tirhisa magqweta ya ku tiva na ku tivanila so va ta hakela swi twala va vona a va lava na vavili a vala va va ku tita vo muyimeli ndi vone vane va khou ḓa uri vha badele milandu ya dziloyara ende ri na ri shumisi dziloyara dza peni ri shumisa dziloyara dzo nḓura ende vha khou ḓo badela
Ralabo Bono Arteleche Agiri Koti NSP Idi Bulala Leka Mabit Ibide di ko YouTube Ori papi maluleka Wari kolata Akuna Mahamas
mani hinkwaro hi swi twile mavona uvona a yi na xihundla yi hlaya timhaka na swi nga xiswona yi ri Maluleke papi wa hi kolota khotsa murao a yi na xiphiri i ri hola monna ono fi papi Maluleke wa ri kolota
Dono, o tlo patala di-cost tshwantse a tlo tlhalosa ka re yena na a re judge o rekilwe akere mara bona bana ne ba re motho o rekilwe ba thabile
ya leswi a faneleke a swi hakela swona hi leswi a nga humesa marito a tlhela a tsala a tlhela a tiboha a ku leswi ni swi tsalaka i ntiyiso ku nga ri ntiyiso a byela vavanuna lavaya a ku no jaji yi xaviwile mara vona lava se va balekile i fanele a ta ti hlamulela a tlhela a hakela zwine a khou tea uri a badele zwone o to ya ṅwala fhasi ha muano a ri jaji o rengiwa zwino u khou tea uri a ḓe a badele zwezwo men men power power tahu tahu egolo egolo tahu egolo tahu egolo ya lungula juta ya lungula juta favorites favorites jatau jatau Pembatala jadi pembatala jadi kalau dia bisa kalau dia bisa bambujo bambujo men 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 power power pembatala jadi pembatala jadi men pembatala jadi kalau dia bisa pembatala jadi men 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 pembatala jadi
win ka moka tša kereke di wela kereke akere tao ye kgolo le kgolo juta e win ka moka tša tao di wela go mang ware le beletše go YouTube oro motse a tshwere tša kereke a buse tša kereke
awa isona leswi
kereke yi nga wina kumbe yi nga hlula swi vula ku ri hinkwaswo swa kereke swi ya kwini siku rin'wana swi nga endleka u tiva un'wana a khome swa kereke a nga ri wa kereke leyi u n'wi byela ku ri a swi lava Judicial winner. Se a voz dos outros anda a Judicial se não era uma boa para levar um dia para zaquere. Mas por não mudar a coisa zaquere. Levante vai ter que requeñar para que a polícia como Moçambique, como Botswana, como Lesotho, como Springs, como Lens, a de mulher do Chata. Mas tem mais sponsorship massiva. Enquanto nós vamos casar com pessoas Iphc, se não catalega com o Queen, abasuque, abasucevito, abaepune. Vai te passar. Ngati venga de mouse. Zote tingaba zikutswana kana Lensi kana Lesotho sinazo bazomali wo Iphc zote ka zitutiwe Dano dinto khulu tsotsotsi bakaba ngala ko Facebook ya so right mona ba go check mola mapolisa ona over that's a record order ya go the high court. You know, abatomo puta dilo chabona riasa. Matitira musokoti. Musokoti takutsuka. Zate hovorala takutsuka. Zitafamba kami akwambia ya hende na ikulu. Zitaba umesa. Loko banga hatlisi psanta kuna zilakela le hande. Baba diva baba masunzi ala ati ya varalo tsuku. Basangwa bilera zipando chibila bachia amo wetona bajoya babisa zone batolisa baba muzoni kaba beba pere. No. Bana war badi amikiti bana peba yemichele abuya ikisalani bangwana vikilerika hela ba ku humesa malovolo abaku batangena hi September kwale famba ni ba thera ku vanga hayi kahina Unabangwe bako zituzanyela minyanya ore bako yo tena minyanya sino kababa mutho uri basendele kule basongo basendela bero kari planetary na arna mohau are gram mutho ala kile ke tele re ichi magyari Ingisalani Aniri vikileria ipuelano Abalungini bakubaya kwale Marabanga basanga ni
loko va kuma va layitela kun'wana ha raha rawana ka to dizanyana so mo dizanyana zone ko la ka do bana na chizi rawana bo kuza ku phedela kwabo riko kutsima
Tau itala tupa 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 yeta Tau itala tupa 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 yeta Tau itala tupa 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 yeah Tau itala tupa sama tupa yeah Tau itala tupa Tau itala tupa Pepe para pepe pa tupa tupa yeta Tau itala tupa sama tupa yeah Tau itala tupa Amanda, viva UAT, viva, viva UAT, viva, viva UAT, viva. Tawi abaraba, Tawi abaraba. UAT, I roll. Pansy ka corruption, pansy. Pansy ka corruption, pansy. Pambili ka justice system, pambili. Pambili ka justice system, pambili. Joas, Renalenu, Naresafa, Bakere report. Harif Taris Relay Mohari Joas, Zakir. Taveri Bola Modi Joas. Kiuri Moetapi. Wakaragene Hululi Siba. Yadi Koshata Munat. Iphc. Murimona Kiba. Joas in service.
Batiri. Mwinami enda kasuhumelela. Ai ranga inika shiviko ka kereke. Mara leswi ai vula swona hi leswi. Murhangeri wa kereke liya leyikulu leyi mi yi tivaka ya tinsimu leti horisaka i hlurile. Swi la ku ri na n'weti Duwasi mi ta yi landzelela ma yi vona ku ri hi yona. Ri ri ka Duwasi va yiti vane va yita Robert Katitofa reporto kama kereke ndo takabo. Robert story bas dibe story kereke hela kuwa nene baidiba. Ine yabana nyimbo zine zatakaza zine bazidiba. Muraka panda wayo ninyi. Ziyamba zori na mwani nizuwazi bakotele.
Yano Panavantate Mamatari Tabi from 2016 Rita Gonamo Rita Mudimuani Mamata Mudimuani taking the great king of Judah. When I apologize. We're not going to want to go to Facebook in the High Court.
Mabona kusuka 2016 isivile kuyigechaikade kumbe ichaikade kana kuna barila kuna monta swende kusotana statana ebaba mara kusuka 2016 kufika na monta haikuikawa chikwebusha na monta chikwebusha ndizo ingala leikulu ya rishakara Yuda. Pambili tau pambili. Babona uba 2016 Robert Chibarko dapa no niriko tambura ritiko toda mudzimu wa bukuma. Zina namusi riaka nwamba uri mudzimu wa bukuma mudzimu wa ngoni ndakuri ya rishakara Yuda.
Bano Panavantate ta High Court kitsona tsiya. Aona mutato wa High Court ka leadership battle. The leadership battle here, the Iphc. Ifella mu. Oya pele mudimu ayo na ke the great lion king of Judah. Bano to us relevo ga re supportile go fitla ka tsheko. Ka di 30 March re dumelane gore lo shala case e morao re lebelle ditsotsi tse gore ha ba interfere again because re na le ditwa sa mo warna ka ba le case governor re aya a re nya ke gore ba re ka ba misriti again kana ditwa ra le lebo re le ka muso ga I wile matwa emel Amanda Karawatau Air Force One wale level had it was Karawatau the great and king of Judah Arwale Lebuga Mujimaru Narwale Lebuga Mujimaru Narwale Lebuga Arratwar Takanakaya again. The Iphc go. The Takanakai. Aona yung muntalyo. Pero ralebuha juas ralebuha Panavantate mereko samele boots. Whenever he pakaurno taukyo. Awasa tsepi kama kamo kote mapolisa shiata batish. Bato cheka ralebuha Panavantate. Tau! tupa yetha amandla awethu amandla twas dijo di gona le metsi a re je ba re je re ska shiana akere sithi let us yezayo let us yezayo let us yezayo sithi let us yezayo let us yezayo let us yezayo sithi let us yezayo let us yezayo let us yezayo shaba 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 sithi valo valo tololo valo valo tololo valo tololo sithi valo valo tololo valo valo tololo valo tololo sithi let us yezayo let us yezayo let us yezayo sithi let us yezayo let us yezayo let us yezayo au sithi valo valo tololo valo valo tololo valo tololo sithi valo valo tololo valo valo tololo valo tololo amandla awethu twas yabana bantata akere busy shilo please resta move arenya go rethabile so re tle re swabe o mo wa rena activate akere mo magweng are emeng gona mo re emele di busy arena re tsamaye re ba botse gore o wine mang o di wa Iphc ke mang o di wa Iphc ke mang re tsamaya le mang re thabetse mang re dinero mang ai sekoletlo ya haimot sekoletlo ya benyam mopane na lena tika kona aniri mutlabela sei no hey mamtaror wala bro hey arolo ikabene relora fala ni wajamut dos mori bisimo agarra sevan agarra sevana amma sipanyoni azo mo passing aitsamani motho a malala na shedi motho tsama kae agarra sevana baba matlega di train baba matlega di toki baba matlega di pere baba matlega di bicycle baba matlega di motorbike baba ngari bus baba ngari train baba ngari aeroplane re tla go tau
Shikadau Yalitala Yashutala Yerusalem Atawiyana Yalitala
Ufelo ya puso ya tauye na kipenyo yako. Nasita kabano ya ufelo ya puso ya tauye na kipenyo yako. Kabano ya ufelo ya puso ya tauye na kipenyo yako. Avanza Jerusalem, unabola melele manto. Avanza Jerusalem, unabola melele. Avanza Jerusalem. Wana mutobola melele manto. Avanza Jerusalem. Mutobola melele. Avanza Jerusalem. Oh, wana mutobola melele manto. Avanza Jerusalem. Mutobola melele manto. Avanza Jerusalem. Wana mutobola melele manto. Avanza Jerusalem. Mutobola. Kabano yabo felo ya puso ya tawiye na kipenyo yako. Kabano yabo felo ya puso ya tawiye na kipenyo. Asintama. Kabano yabo felo ya puso ya tawiye. Hasa. Awancha Jerusalem. Oh, wana utabola melele maso. Awancha Jerusalem. Mutambola, Awancha Jerusalem, Olo Wana Mutambola, Melele Maso, Awancha Jerusalem, Mutambola, Melele Maso. se se le mobutu ke moya o halalela se mo oro tuletse tsohle ka moya wa gagwe re tseba diphiri makutu ka moya ona wa gagwe awatsata olo butobolo awatsata utabola awatsata olo butobolo awatsata utabola Felo ya puso ya tawi na kipenyo yako. Felo ya puso ya tawi. Awata Jerusalem, wana kutobola, melele maso. Awata Jerusalem, wana melele maso. Awata Jerusalem, wana kutobola, melele maso. Awata Jerusalem, wana bola. Awata Jerusalem, wana kutobola, melele maso. Awata Jerusalem, wana bola. Awata Jerusalem, wana kutobola, melele maso. Awata Jerusalem, wana bola, melele maso. Tabano ya mufelo so ya tawina kipenyo ya. Tabano ya mufelo ya puso ya tawina kipenyo ya. Tabano ya mufelo ya puso ya tawina kipenyo ya. Tabano ya mufelo ya puso ya tawina kipenyo ya. Awata Jerusalem, Awata Jerusalem, Awata Jerusalem,
Jerusalem.
Basi ya segunda ya tsamaya. Basi ya segunda ya tsamaya. Brooklyn bus ya tsamaya. Moranyaka bus ya tsamaya. Vembe bus ya tsamaya. Mabopane bus ya tsamaya. Basi ya Sekhukhune kamo ya tsamaya. Basi ya Sekhukhune ke tsela mola ya tsamaya. Vembe e ka morao ya tsamaya. Segunda ya tsamaya. Zone 10 ya tsamaya. Orange Farm ya tsamaya. Mabapane ya tsamaya. Kimberley ya tsamaya. Davidton ya tsamaya. Fine Town ya tsamaya. Botswana le yona kama ya tsamaya. Ya passing, ya passing, ya passing. Ya passing, ya passing. Tebo, tebo, tebo. Passing, ya passing. Segunda, Fine Town, Orange Farm, Tembisa. Ya tsamaya. Ya passing, ya passing, ya passing. Ya tsamaya. Basi tilengani doas Machiding Falbank Siabuso ya tsamaya. Machiding Falbank Siabuso basi doas ya tsamaya. Tate Makasane wa tlhokega mo stage. Tate Makasane wa tlhokega. Basi ya Amatona ya Velcom ya tsamaya. Rustenburg ya tsamaya. Bloemfontein ya tsamaya. Ha o tlile ka dipase ya dipaseng. Ha o tlile ka dipase o no dipaseng. Mamela o dipase ke ela mona. di pili makubutu kamoya ona wala aura tata uye aura tata uye aura melele maso Moya wohala lena, muliti uyena. moya wa hare Reciba di pirili makuchu Kamoya wona wa hare Awatana uyena Awatana uyena Awatana uyena Awatana uyena Kabano ya mufelo ya puso ya trawira